This video will introduce you to the sources of law in our legal system. In our system, the law comes from federal and individual state governments. It also comes from municipalities like cities, towns, and counties, but we'll talk about those later. These governments didn't just pop into existence by themselves. They were created by the people through constitutions. Written constitutions establish the structure of the government and delineate the powers the government has and the limitations on those powers. Constitutions are the foundational law for the government they create. The federal government was created by the U.S. Constitution. It is a relatively short document that sets out the framework for the government and the powers the people have granted it. If you haven't read it, you should. You might be surprised by some of the things it contains and some of the things it doesn't. State constitutions tend to be much longer and more detailed than the U.S. Constitution. Rather than setting out a mere framework for the government and its powers, state constitutions often go into exquisite detail about how the government will operate and what it can and cannot do. The California Constitution is no exception. Reading a state constitution is often a major undertaking. Links to the federal and California constitutions are provided in the recommended reading for this class. Our federal and state governments are organized by their constitutions into three separate branches of government: legislative, executive, and judicial. In the federal government and all but one state government, the legislative branch is divided into two chambers. The sole exception is Nebraska, where the legislature has only one chamber. In the federal system, the chambers are called the House of Representatives and the Senate. States differ in what they call their chambers. California calls its chambers the Assembly and the Senate. I bet your high school civics teacher told you that the branch that makes law is the legislative branch. That's true as far as it goes. In reality, all three branches make law. Let's look at them one at a time. A government's enacted law consists of its constitutions and the law created by its legislative and executive branches. The legislative branch creates statutory law. Laws passed by the legislature are called statutes. We will go into much more detail about statutes in later videos. The administrative agencies in the executive branch promulgate regulations, sometimes called rules. Legislatures enact statutes, but agencies promulgate regulations. I don't know why. These regulations have the same force and effect as statutes. You can even go to jail for violating some regulations. Caveat: this whole category of law is in question right now because of a recent decision by the Supreme Court in 2022. We will update the video when needed, but for now we will teach the subject as we always have. The courts do two things. First, courts interpret the law created by the other branches and apply it to the facts in a given case. And second, they create the common law. That's right, courts create law. So I said courts interpret the law. Well, why? Sometimes the law is not clear, or the law might not be clear in a given context, and so the courts have to determine what it means in that context. Sometimes the language of a statute or regulation is so long and complex that the court must closely analyze the language to decide how it applies. I will show you examples of both of these when we cover researching case law. There are several types of legal systems in the world. Western countries are mostly either common law legal systems or civil law, that is, Roman law systems. England was the birthplace of the common law system, and the countries that were part of the British Empire, like the United States, are mostly common law countries. In England, there was very little enacted law, because Parliament didn't really exist until the 13th century and was mostly concerned with authorizing the raising of taxes. What little enacted law there was came from the king and his council. By contrast, European countries such as Germany and France have civil law systems that grew out of the Roman law system. Their law is based entirely on enacted law. The courts and civil law systems do not create law themselves, but do interpret and apply the enacted law to the facts before them. Basically, the common law is judge-made law. It is developed through judicial decisions issued over time and allowed to grow and tailor itself to meet changing needs within the doctrine of stare decisis. The common law evolves and changes as society changes. The common law can be abrogated, that is, changed by the legislature. So if the legislature doesn't like the approach the court takes toward an issue, it can pass a statute changing that law. I will show you examples of the common law and the doctrine of stare decisis when we cover researching case law. One of the videos in this module discusses the doctrine of stare decisis, and I will show you examples of the common law and stare decisis when we cover case law. The next video is called The Court System.